The notion of a restoration. Here's this layman's first question. The Warren Court, which is the Supreme Court under Chief Justice Earl Warren, who served as chief from 1953 to 1969, let me quote legal scholar Daniel Frost, quote, Chief Justice Warren is remembered primarily for extending rights to the weak, the disenfranchised, and the oppressed. But even his admirers are not entirely certain the Constitution authorized him to do so. Then beginning in the 1990s, I'm putting this to you to see if I have the basic point here correct. Beginning in the 1980s or so, there arises a school that stresses that reasserts the importance of the original meaning of the Constitution, a school we now call loosely originalism. I believe you've called yourself a modified originalist. We can come to those modifications. Let me quote the late Justice Antonin Scalia, quote, the Constitution is not a living organism for Pete's sake. It's a legal document, and like all legal documents, it says some things, and it doesn't say others. So would it be correct to say that the originalist school does not see itself as a new school or doctrine of interpretation, but as a group of like-minded scholars and lawyers who are engaged in what they see as an act of restoration? Is that a fair summary?
I think that is a fair summary. I think that the review of history that you provided is a fair one. A very sympathetic biographer of Chief Justice Warren said, and obviously I can't quote directly, but from memory, but he said that Chief Justice Warren had such strong views about what was good and right and beneficial for society that he didn't think those things were disputable. And that was embodied in a lot of the work that was done during the Warren years. Sometimes it produced tremendous results like Brown versus Board of Education. Sometimes the results were more debatable. And when the Warren era ended, scholars looked back and I think they struggled to try to find a principled basis for the decisions that the Warren Court had handed down. So that inaugurated a period of debate about how the Constitution should be interpreted. Justice Scalia, Judge Robert Bork, who was then a professor at Yale Law School, Ed Meese later, when he became counselor to President Reagan and Attorney General, were I think the three pioneers of this originalist movement. And what they argued is basically that the Constitution is a text and it should be read basically the way other texts are read. We read the words, they're understandable. The English language hasn't changed that much since the late 18th century. We can figure out what it means, where it refers to legal concepts, established legal principles. We can explore what they were understood to mean at the time, and that's the way it should be interpreted. So it was an effort to provide a structured, disciplined, and restrained way of reading the Constitution.